The Justice Committee will now come to order. Members, please register your attendance on the electronic voting device. All members have voted their attendance. Clerk will please close the roll, and we do have a quorum. All right, let's go ahead and take care of some administrative items as we get going here. And I see Delegate McQuinn is here. Delegate McQuinn, let me do some administrative items, and I will turn to you. We have some bills that are going to be continued, and I'm going to call these bills out in a block, and this will be a voice vote. House Bill 240, patroned by Delegate Gardner. House Bill 853, patron Delegate Cousins. House Bill 1027, patron Delegate Walker. House Bill 1346, patron Delegate Clark. House Bill 1506, patron Delegate Phillips. House Bill 42, patron Delegate Simon. House Bill 752, patron Delegate Runyon. And House Bill 886, patron Delegate Hope. So I get a motion to continue those under Rule 22 to 2027.
So moved.
Got a motion and properly second. All in favor say aye.
Aye.
Opposed? Okay, those bills are all continued to 2027. I'm going to turn to my Vice Chair Maldonado for a motion.
Thank you, Mr. Chair. Mr. Chair, having voted on the prevailing side by which we passed HB 1298, I ask that we reconsider that motion to replace it with a different one.
Okay, to reconsider. I got a motion and Watts seconds. All in favor say aye.
Aye.
Opposed? Okay, so motion to reconsider passes. Delegate Maldonado.
Thank you, Mr. Chair. Mr. Chair, I move that we report with substitute and refer to appropriations, HB 1298.
Got a motion, Simon seconds. House Bill 1298 to report and refer with substitute to appropriations. Any members have any questions? Okay, members, please. Clerk will please open the roll. Clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 1298 reports and refers with substitute to appropriations by a vote of 22-0. We do have one bill that we need to get out and upstairs today in full committee, and that is Delegate McQuinn's bill. And Delegate McQuinn, House Bill 193, if you'd like to come forward and tell us what your bill does.
Good afternoon, and thank you, Mr. Chair and members of the committee. My bill, House Bill 193, is a result of a Supreme Court ruling decision that was made in Fishback versus the Commonwealth of Virginia in 2000. This bill, what it does, I bring it before you because it is a bill that implements a Fishback remedy for people sentenced by juries that were not instructed that that parole had been abolished. It ensures sentencing reflects what the jury actually intended, not assumption based on outdated parole laws. What the bill does is it makes a person eligible to be considered for parole, not released, but considered if all of the statutory criteria are met. It applies only to individuals sentenced by a jury after the Supreme Court's decision in Fishback versus the Commonwealth in 2000. It applies to those convicted of a felony committed on or after January 1, 1995, when parole was abolished. And it applies to those who can prove by preponderance of the evidence that the jury was not instructed that the parole had been abolished. And it applies to those who remain incarcerated for that offense as of July 1, 2026. And so the bill expressly exclude Class 1 felonies, those who are serial sexual offense involving minors, including rape, forcible sodomy, sexual penetration, aggravated sexual battery, or attempt to commit those offenses. And Mr. Chair, this is basically the essence of it, what I'm bringing before you for those persons who were still in the system, had not been told at that time that they were eligible for parole. And so we wanted to make sure that it may be probably a small group of individuals, but we want to make sure that they have an opportunity. And we have individuals who are here, some of the experts in this, who are also want to speak on this particular issue.
Okay, all the members of the courts committee that are fortunate enough not to be on criminal sub, this is your opportunity to get a flavor for what happens in criminal sub. So welcome to the full committee, Delegate McQuinn. Any members wish to ask the patron a question? Please do your request to speak button. I don't see anyone.
Mr. Chair,
Okay.
anyone except for Simon. But
Yeah,
anyway.
no, we've muted his mic. Don't worry. All right, so anyone here to speak in favor of House Bill 193, please come forward. And all the folks, if you would line up so I can see how many people are, because I want to make sure that we're being fair for the testimony. What I'd like to do, if this is okay, is I'd like to have 5 minutes total for everyone to speak. Would that be sufficient? If, as a group, we can sort of discuss how many, 5 minutes for the entire pro side? Because we do have people online.
Okay.
So why don't we go ahead? So let's start a time for 5 minutes. Thank you for being here.
Okay, everyone is not going to speak. They're just here as in unity.
All right, well, maybe less than 5.
Okay. Hello. I am Lily Branch Kennedy, founder of the Resource Information Help for the Disadvantaged and the Disenfranchised, RIHD, a nonprofit organization. On behalf of RIHD, I respectfully request that you vote in favor of House Bill HB 193, which would expand parole eligibility to certain individuals. On June 9, 2000, the Virginia Supreme Court ruled in Fishback versus Commonwealth that jury trials must be instructed that parole was abolished. In 2020, Virginia Senate Bill 793 was passed into law, allowing parole consideration for certain prisoners sentenced between January 1st, 1995 and June 9th, 2000, whereas the jury was not instructed that parole was or had been abolished. Unfortunately, some individuals eligible under SB 793 were not included due to circumstances beyond their control and judicial noncompliance with instructing jurors that parole was abolished. HB 193 seeks to rectify these inequities concerning jury instructions on parole by expanding parole eligibility to those affected. Please vote in favor of this important and needed bill. Thank you. Is there anybody
Thank you very
else?
much.
Do you have any more time?
Yeah, please come forward.
Good afternoon. My name is Carla Johnson, and I'm hoping and praying that you will pass this bill because I have a brother who was sentenced in 1996, and he has, as of last month, been incarcerated for 30 years. And his name is Dana Holloman. I'm very, very proud of him as a brother, a man, a human being. His state ID number is 107-7138. Anybody who meets me, you would think he would be out because I'm always talking about him. And I even have an old neighbor that's a wonderful friend of mine. She's like a big sister. I asked her to take a ride with me so that I could plead my brother's case today.
Thank you.
Thank you.
Thank you so much for being here.
You got to make it fast. Time is of the essence.
Mr. Chair, members of the committee, we thank the delegate for bringing this bill, Valerie Slater, Executive Director of Rise for Youth, and the Criminal Justice Chair for the Virginia State Conference, NAACP. We support this bill.
Thank you.
Hi, my name is Lynetta Thompson, and I would just like to say, please take true consideration of this bill because, again, this can rectify a lot of what has been wrong and what is wrong with the system. So really appreciate if you will take this very serious.
Thank you.
Hi, I'm Jennifer Dalton. I'm the Executive Director of Virginia Justice Alliance, and we support this bill.
Thank you. All right. Thank you. Is there anyone in the audience to speak in opposition to House Bill 193? I don't see anyone. Okay, so we do have people online, and so I want to open up the phone line. We've got 1, 2, 3, 5 people. If you could just do 1 minute apiece, I would appreciate it. And so let's start with Kimberly Dyke Harsley. Kimberly?
Thank you, Mr. Chair. Are you able to hear me?
Kimberly, please proceed.
Mr. Chair, my name is Kimberly Dyke Harsley, coming in from the city of Lynchburg as a constituent of Delegate Wendell Walker. We ask that this bill be moved forward and that you vote yes to move it forward in an effort to correct some of the truth in sentencing that has plagued the lives and the judicial noncompliance for this. And also, we do know that each case is not a monolith. So we need to carefully look. I will yield the rest of my time. Thank you.
Thank you. Next is Allison Chafin. Allison? Is Allison? I don't see Allison. Let me go on to Fatima Mohadi. Fatima?
Thank you, Mr. Chair. Members of the committee, I'm Fatima Mohadi, co-representative for the Virginia chapter of Survivors for Justice Reform. We support HB 193 because justice must be honest. As survivors, we believe a sentence based on misinformation violates the integrity of the law. Correcting this doesn't erase harm, it fixes the harm created by the state. We urge you to support HB 193 to restore transparency and fairness to Virginia's system. For all of the previous reasons stated, we support this bill. Thank you.
Thank you. Kirsten Knights. Kirsten, are you with us? I don't see Kirsten, so let me go down to Brenda Coles. Brenda, are you there? Brenda, I think I see you just unmute and we don't see your screen. Can you turn on your screen?
Okay, can you hear me?
Can you turn on your video, Brenda?
Yes, sir. Okay, so can you hear me? Wait a minute. Hi, sorry about that. Thank you, Chairman. My name is Brenda Coles, 40 years of civil rights and social justice. Thank you for allowing me to speak on my support of HB 193. The Supreme Court of Virginia decision on Fishback versus Commonwealth in 2000, in which the Supreme Court held the jury to be instructed on the fact that parole has been abolished. HB 193 does not guarantee freedom for anyone. It simply allows eligible individuals to be reviewed by the Virginia Parole Board. HB 193 expanding parole eligibility, Fishback persons were left out of the 2020 SB 793 law. HB 193 asks only for judges to come in compliance with said law. I ask your chairman to please pass the House Bill 193 only to correct an injustice. Thank you.
Thank you. All right, that completes the testimony. I've turned it back to the committee. Does any member wish to seek recognition? I don't see anyone requesting to speak. What's the pleasure of the committee? If you were to vote favorably for this, report favorably, it'd have to go upstairs to appropriations.
Mr. Chair, I move to report and refer to appropriations.
You got a motion and properly second to report and refer to appropriations, House Bill 193. And I got a second. Clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 193 reports and refer to appropriations by a vote of 14-7. Thank you, Delegate McQuinn.
Thank you. Thank you, committee.
Okay, so with that, why don't I go ahead and turn to the work of the subcommittees, and I'll start with Criminal Subcommittee with Chairwoman Watts. Chair Watts.
Thank you, Mr. Chairman. We have before you first, I'd like to report on a block of recommended to report uncontested, and I'd like to move all the amendments and substitutes for the bills that I will bring forward.
Got a motion and properly second to move all the substitutes and amendments. All in favor say aye. Aye. Opposed? All right, approved. Chair Watts.
Thank you. The first one in the block is HB 150, Patron Williams, and it provides that the speedy trial statute is tolled by continuance granted on the motion of the accused by the court or for the accused retaining private counsel or having counsel appoint to him in relevant law. It requires the trial court to conduct no more than 30 days apart reviews of the accused attorney's status, and that the tolling of speedy trial shall end when the accused has either retained counsel or had counsel appointed to him and such counsel has entered an appearance in the case, or that the accused has executed a waiver of counsel. It also provides that such provision shall not be construed as ending the tolling of speedy trial for any other reason pursuant to relevant law. The next one, and this was, again, all of these were recommended unanimously. The next is HB 441, Chairman Uber Chairman Hope. It is a major structuring of the Judicial Inquiry and Review Commission, and it increases from 7 to 12 the number of members on the commission by adding 2 additional attorneys to be recommended by a select number of associations, including the State Bar and the Association of Commonwealth's Attorneys and the Association of Criminal Defense Lawyers. It also requires that the Commission adopt and implement a conflict of interest policy. It also provides that the Commission shall make all reasonable efforts to contact any witnesses specified in complaints alleging judicial misconduct to assist the Commission. Further, the bill clarifies that the Commission may investigate any complaints within their purview arising out of matters that are pending or on appeal, and not to dismiss such complaints solely on the basis that the matter from which the complaint arose is pending or on appeal. It also requires that the Commission make publicly available a publication specifying all possible sanctions and disciplinary actions and supervision of the agreements. And finally, I would highlight, along with other changes, that the bill removes provisions of confidentiality for a complainant that currently bars a complainant from discussing or sharing privileged information regarding any filed complaint, and permits such complainant to discuss publicly the filing of a complaint and any associated events relating to the complaint. The bill finally, and this is the final, requires that the Office of the Executive Secretary of the Supreme Court provide the annual judicial performance evaluation for all judges subject to evaluation to the Commission, and that such evaluation shall remain confidential. The next one is HB 561, again from Uber Chair Hope, and this deals with driving while intoxicated and provides for an restricted license with immediate installation of ignition interlock. It also directs the Commission VASAP to convene a work group to evaluate the provisions governing or operating a motor vehicle when you're under the influence of alcohol, and submitting recommendations to the chairs of the House and Senate Committees on Courts by November of this year. The next bill is HB 690, and it provides that an affidavit that accompanies a search warrant for a place of abode that has been sealed pursuant to relevant law, that the executing law enforcement does not have to leave a copy of such affidavit, just the search warrant, in a conspicuous place within or affixed to the place to be searched. The next bill, 862, also deals with the Virginia Alcohol Safety Action Program, VASAP, and it has a delayed effective date that will allow the study of restructuring the VASAP program as far as local and state responsibilities and the factors affecting the funding and the sustainability of the program, including the fees and the funding source for the program. And then finally, in this block, we have HB 1219, Sewell, which deals with the use of unmanned aircraft systems, or drones, and the substitute permits the use of drones without a search warrant, but only to capture digital documentation of a crime scene or to respond to a public safety call for service, and only when such crime scene or call for service is located on public property. It also allows providing real-time aerial observation to increase unseen safety and security, emergency, and deliver essential supplies. And then it also continues to provide aerial survey of public property incidental to a call for service for purposes of locating and identifying any person on such public property of such persons of interest while law enforcement officer is physically en route to the location. The substitute has a reenactment clause on the provisions related to the use of drones and directs DCJS to establish a model policy by December of this year.
Okay, thank you. Chair
I
Watts.
move the bills to be reported as amended and substituted.
Okay. Before we do that, I want to go back to House Bill 690 and incorporate House Bill 1028, and we can do that by voice vote. Can I get a motion?
So moved.
Motion properly second to incorporate House Bill 1028 into House Bill 690. All in favor say aye.
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 Okay, that is approved. So back to your motion. I'm going to ask now that if many members want to pull a bill from the block, I have already teed up. I'm already listening to you, Delegate Cousins. House Bill 862 and House Bill 1219 to be removed from the block. Do any other members wish to pull any bills mentioned by Chair Watts from the block? All right, seeing none? Okay, members, I got a motion and properly second to report on the block. Clerk will please open the roll. Members, please cast your votes. Clerk will please close the roll. All right, those bills report 19-0. Why don't we go back then to Delegate Cousins' bill for a line amendment? House Bill 862, and Mr. Hatcher, would you please report the line amendment?
Yes, Mr. Chairman, members of the subcommittee, full committee, I guess now. The subcommittee adopted some line amendments, and those line amendments need to have some slight changes. The line amendment that was added as amendment number 3 that adds enactment clauses number 7 and 8. Number 7 was the delayed effective date of a code section. It needs to also add subsection D of code section 18.2-273.4 and then change that delayed effective date from July 1, 2027 to January 1, 2028. In the 8th enactment clause that's being added, it will be removing the Office of the Executive Secretary from the work group.
Okay. Can I get a motion to adopt the line amendments? Got a motion properly second to adopt the line amendments. All in favor say aye. Aye. Opposed? All right. Those line amendments are adopted. So back to the motion to report as amended House Bill 862. Can I get a motion? Got a motion and properly second to report House Bill 862 as amended. Clerk will please open the roll. All members have voted. Clerk will please close the roll. House Bill 862 reports as amended 21-0. Now let's turn our attention to House Bill 1219 for a line amendment. Mr. Hatcher.
Thank you, Mr. Chair, members of the full committee. In the robust discussion that occurred during the subcommittee regarding the Fourth Amendment and the use of the drones, we put a reenactment clause on any of the changes going in to 19.2-60.1 and instead wanted the DCJS to move forward with creating the model policy. And speaking with Delegate Sewell, she wanted to ensure that attorneys were also in the room to make sure the Fourth Amendment conversation was protected in creating this model policy. So where we are creating the new 73 power and duty, at the very beginning of it, it'll just say, in consultation with the Virginia Indigent Defense Commission and the Virginia Association of Commonwealth's Attorneys, establish a model policy, ...
Okay, that's the line amendment. I can get a motion to adopt. A motion properly second to adopt a line amendment. 1219, all in favor say aye. Aye. Opposed? All right, that line amendment is adopted. So I'll entertain a motion to report as amended, House Bill 1219. A motion and properly second to report House Bill 1219 as amended. Clerk will please open the roll. All members have voted. Clerk will please close the roll. House Bill 1219 reports as amended by a vote of 22-0. All right, Chair Watts, back to you.
Thank you, Mr. Chairman. Now I will report bills individually that were not recommended unanimously. The first one is HB 438. I move the substitute.
Motion to adopt a substitute. All in favor say aye. Aye. Opposed? All right, substitute's adopted. Chair Watts.
Thank you, Mr. Chairman. HB 438 provides that even if a juvenile has been proceeded against by intake, it permits the court on its own motion or by counsel for the child or the Commonwealth attorney to continue proceedings so as to have the court service unit conduct informal proceedings. The bill pertains to violent juvenile felonies, including those involving a juvenile previously found delinquent for an offense that would be a felony if committed by adult. Currently, the law does not permit proceeding informally when a juvenile commits a juvenile felony or is alleged delinquent for a felony that would be a felony if committed by an adult. The committee recommends that reporting with substitute 8-2, and I would so move.
Got a motion properly second to report House Bill 438 as substitute. Any members wish to seek recognition? All right, seeing none, clerk will please open roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 438 reports with substitute by a vote of 15-7. Chair Watts.
The next one then is HB 637. Delegate Carlson is the patron. I move the substitute, and I understand that there's also a new amendment with a clarifying definition.
All right, do we want to adopt a substitute first and then go to the amendment? So I've got a motion and Simon seconds to adopt a substitute. All in favor say aye. Aye. Opposed? All right, substitute is before us. Mr. Hatcher.
Thank you, Mr. Chair, members of the committee. The definition currently in the substitute for 18.2-250.01, which is the new possession of residue of a controlled substance statute, says, as used in the section, residue means a sample of a controlled substance that is too small to be weighed accurately. We would be adding at the end of that, as defined or reported by the Virginia Department of Forensic Sciences.
All right, that's the amendment. Got a motion to adopt.
So moved.
A motion properly second to adopt the line amendment. All in favor say aye.
Aye.
Opposed? All right, amendment is adopted and bill's properly before us. Chair Watts.
Thank you, Mr. Chairman. HB 637, as substituted an amendment, adds a new code section that is drawn from 18.2-250, the possession of controlled substances, to allow, except for fentanyl, possession of residue of a controlled substance that is too small to be weighed accurately to be charged as a Class 1 misdemeanor. Currently, possession of any amount of such controlled substance is prosecuted as if there is a usable amount of such substance. The subcommittee recommends reporting with substitute 8-2, and I would so move.
Second. Got a motion properly second to adopt the substitute as amended. House Bill 637. Any members wish to seek recognition? All right, seeing none, ask the clerk to please open the roll. All right, members all cast their vote. Members, clerk will please close the roll. House Bill 637 reports with substitute as amended by a vote of 16-6. Chair Watts.
Thank you, Mr. Chairman. The next bill is HB 648, patroned by Delegate Kent, and I move the substitute.
Got a motion of Maldonado seconds to move the substitute. All in favor say aye. Aye. Opposed? All right, substitute's approved. Chair Watts.
Thank you. The substitute makes it unlawful to sell or purchase a container of nitrous oxide that exceeds 8 grams, with professional occupational exceptions, and it also makes it illegal to sell a device of any size designed to deliver nitrous oxide so that a person directly inhales it, or to sell nitrous oxide marketed as tasting or smelling like food. Everything that I have just referred to would be a Class 1 misdemeanor. However, the committee recommends referral to general laws to determine how to enforce nitrous oxide as banned in this in HB 648 from not being offered for sale, as we ban, for example, vaping products and beverages by alcoholic content. So I move the substitute and recommend that it be referred to general laws as recommended by the committee 10-0.
All right.
And I would so move.
All right. You've got a motion and properly second. Delegate Williams, you're recognized.
Yes, Mr. Chair, thank you. Sort of question for you, Mr. Chair. We're recommending sending it to general laws. Do you know what kind of calendar we've got left on general laws before?
Mr. Chair?
Tomorrow. They're meeting tomorrow, I'm being told.
Yeah, it's on my, I've got a holding spot for our Housing and Consumer Subcommittee for tomorrow, so we just need to communicate it over, and we'll have a hearing on it.
Thank you.
Any other members wish to seek recognition on the motion to report House Bill 648 and refer to general laws? All right, clerk will please open the roll.
I'm still going to vote no because I don't want to hear it.
All members have voted. Clerk will please close the roll. House Bill 648 is reported and referred as substitute to general laws by a vote of 22-0. Chair Watts.
Thank you. The next bill is HB 974. I move the line amendments.
Got a motion, Maldonado seconds to move the line amendment. All in favor say aye.
Aye.
Opposed? All right, amendment is adopted. Chair Watts.
Thank you, Mr. Chairman. As amendment, HB 974 provides a review process when the Attorney for the Commonwealth designates a law enforcement officer as a witness with a witness impeachment evidence designation within a certain time frame specified in the bill. The bill defines the impeachment and evidence designation as a determination that is made by or a designation that's created by the Attorney for the Commonwealth relating to a law enforcement officer who is believed to have given inconsistent statements or otherwise engaged in conduct that meets the requirements for disclosure in a criminal prosecution according to the Constitution. The bill prohibits a law enforcement officer from being discharged, disciplined, or threatened with discharge, and it also provides that the law enforcement officer is given 21 days to initiate a response to the Commonwealth Attorney, and within 7 days, the Attorney for the Commonwealth must respond in writing to the law enforcement officer, stating with specificity the grounds on which the Commonwealth Attorney will proceed, or indicating that the review has been satisfied. The committee recommends reporting by a vote of 7-3, and I would so move.
All right, got a motion to report as amendment, House Bill 974, and properly second. All in favor? Oh, well, wait. Any members which seek recognition? All right, clerk, please open roll. Members, please cast your vote.
Sorry to slow everything down.
Delegate Kilgore.
I'm sorry. How is this different, since I'm not on the criminal side, how is this different from already the Commonwealth Attorney providing information about officers who had some, bad acts in the past? How's it? I can't even think of the case name.
Brady.
Giglio. How's it different than Giglio?
Mr. Hatcher, do you have an answer?
Can somebody answer me that?
Chair Watts?
Mr. Chairman, I believe that as I understand I'm sorry, you went counsel. Thank you.
That's fine.
The answer, I would believe that the answer to the question is it sets up a definite process, and it requires things to be in writing. It has a time frame that allows for response, and it also stipulates that this in and of itself is not a reason for dismissal. So it gives a structure for what perhaps is not reported because there is not that structure and there is concern about unintended consequences.
Thank you. Okay. All right. Any other questions? All right. Clerk, will please open the roll. Motion is House Bill 974 to report as amended. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 974 reports as amended by a vote of 16-6. Chair Watts.
Thank you, Mr. Chairman. HB 1070 by Delegate Rasool. I move the substitute.
And a motion to adopt a substitute, properly second. All in favor say aye. Aye. Opposed? All right, substitute is adopted. Chair Watts.
Thank you, Mr. Chairman. HB 1070 is simply described as establishing a procedure for using a defendant's prior convictions to prove an element of an offense charged or to enhance the punishment for the offense charged. The subcommittee recommends reporting with the substitute 7-3, and I would so move. Second.
Got a motion properly second to adopt to report House Bill 1070 with substitute. Any members wish to seek recognition? Kilgore, are you still
yes,
on? Delegate Kilgore, you're
recognized.
recognized
again. Would this apply in a jury trial, for example, if I'm trying a second offense, a DUI, in a misdemeanor case, would it apply in that particular situation?
Mr. Chairman, I would ask counsel to respond.
Ms. Paulus.
Yes, it would apply to that. Yes, sir.
All right. Good. Thank you. So we got a motion to report House Bill 1070 with substitute. Seeing no members wishing to seek recognition, I'd ask the clerk to please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 1070 reports with substitute by a vote of 15-7. Chair Watts.
Thank you, Mr. Chairman. The next bill is HB 1411. The patron is Delegate Schmidt, and I move the substitute.
Got a motion to adopt a substitute. Maldonado seconds. All in favor say aye. Aye. Opposed? All right. Substitute's adopted. Chair Watts.
Thank you, Mr. Chairman. The substitute provides that evidence of a defendant's mental condition at the time of the alleged offense, including lay and expert testimony, may be admitted and considered if such evidence has any tendency to show the defendant did or did not have the mental state that's an element of the offense or an affirmative defense. The substitute also provides that in any criminal case, evidence offered by the defendant concerning the defendant's mental condition at the time or near any act related to the offense or a defense to or for such offense is admissible if it has the tendency to show that the defendant did not have the required mental state. The current standard requires that such evidence tend to show that the defendant did not have the intent to required for the offense charged. Lastly, the substitute provides that notwithstanding any other provision of law or rule of evidence, any statement made by the accused to an expert during an examination pursuant to relevant law to allow such expert to form an opinion on whether or not the accused had a mental condition at the time of or near any act related to the offense or the defense to or such offense is admissible if such statement by the individual is offered by the accused. The subcommittee recommends reporting with substitute 77-3 and referring to appropriations, and I would so move.
Second. Got a motion to report House Bill 1411 and refer to appropriations with substitute. Got a motion properly second. Any members wish to seek recognition? All right, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 1411 reports and refers with substitute to appropriations by a vote of 15-7. Chair Watts.
Thank you, Mr. Chairman. The next bill is HB 1432 by Meta, and I move the substitute.
Second.
Got a motion to adopt a substitute, properly second. All in favor say aye. Aye. Opposed? All right, substitute's approved. Chair Watts.
Thank you, Mr. Chairman. HB 1432 reduces the penalties for underage consumption or possession of alcohol or marijuana in progressive use, to progressive use for subsequent violations of written warnings, informational materials, and referral to access community services. The law enforcement officer is authorized to confiscate the alcohol or marijuana, but must use a body camera and cannot conduct a search unless related to a different illegal act. The DUI, there is no change to DUI. There's no change to be intoxicated in public, and there's no change in any existing parental notification. In fact, it doesn't appear actually that when I looked at it, any currently exists, that there's no change at all in the current status. The committee recommends reporting by a vote of 7-3, and I would so move.
All right. Second. Got a motion, Simon seconds, to report House Bill 1432 with substitute. Does not need to go to appropriations. And so any members wish to seek recognition? Seeing none, clerk will please open the roll. Members, please cast your votes. There we go.
I'm trying to record.
Yep.
Okay.
All right.
Okay.
All members have voted. Clerk will please close the roll. House Bill 1432 reports with substitute by a vote of 13-9. All right, Delegate Watts.
Thank you, Mr. Chairman. And the final bill, reporting from the Criminal Law Subcommittee, is HB 1464, patroned by Shin, and I move the line amendments.
Got a motion, Maldonado seconds to move the line amendment. All in favor say aye. Aye. Opposed? All right, amendment's adopted. Chair Watts.
Thank you, Mr. Chairman. HB 1464 requires, first, as with alleged sexual assault, that all medical fees for trace evidence collection kits examinations conducted on victims complaining of strangulation be paid by the Virginia Victims Fund, and that victims aren't required to cooperate with law enforcement to be provided the medical exams, again paralleling what is the law for alleged sexual assault. It also directs DCJS to convene a work group of stakeholders to make recommendations related to the reimbursement process for forensic medical exams. The subcommittee recommends reporting as amended 9-1 and referring to appropriations, and I would so move.
Got a motion, Maldonado seconds to report and refer with amendment, House Bill 1464, refer to appropriations. Any members wish to seek recognition? All right, seeing none, I would ask the clerk to please open the roll. Members, please cast your votes. All members have voted. Our clerk will please close the roll. House Bill 1464 reports and refers with amendment to appropriations by a vote of 22-0. Thank you, Chair Watts, for that very in-depth report. For the civil sub, I will turn now to Chair Simon for his report.
Thank you, Mr. Chairman. Mr. Chairman, we've got 21 bills that we've reported in one way, shape, or form out of civil sub, so I will try and move quickly. First, I have an uncontested block of 13 bills. I'd like to move all the amendments and substitutes for that block of 13 uncontested bills.
Got a motion and properly second to adopt all the substitutes and amendments in this block. All in favor say aye. Aye. Opposed? All right. All substitutes and amendments are approved. Chair Simon.
House Bill 593 from Delegate Simons, as amended by the subcommittee, provides that any summons for an unlawful detainer issued may, with the approval of the Chief Judge of the General District Court or the Chief Judge of the Circuit Court, include additional information prepared by the Commonwealth, the locality, or a nonprofit organization regarding legal resources available to the plaintiff and defendant, in plain language overview of the unlawful detainer process and eviction diversion program eligibility and applicability. Subcommittee recommended reporting with amendments 10-0. House Bill 733 from Delegate Leftwich has to do with easements and provides that the owner of an servient estate upon which an easement lies may establish reasonable rules for the use of such easement, including speed limits. Bill further provides that a servient estate owner may bring a civil action against someone in violation of such reasonable rules and recover actual damages or $500, whichever is greater. Subcommittee recommended reporting with amendment 10-0. House Bill 845 from Delegate Cousins provides that an initial hearing on an unlawful detainer If the defendant contests the amount of rent and damages alleged to be due and owing to the plaintiff, the court shall not bifurcate the unlawful detainer case. Subcommittee recommended reporting 10-0. House Bill 1235 from Delegate Delaney, as amended by the substitute adopted by the subcommittee, provides that if a clerk's office allows payments to occur via an already established online payment system for the collection of court fines and fees and costs, it will also offer such payment method for all restitution payments. The bill further directs the Office of the Executive Secretary of the Supreme Court of Virginia to convene a work group to study the accessibility and modernization of court payment systems. Subcommittee recommended reporting with substitute by a vote of 10-0. House Bill 1327 from Delegate Tata deals with the definition of fictive kin. As amended by the substitute adopted by the subcommittee, the bill updates the definition of fictive kin to specify that such person is required to have an established relationship with a child or his family prior to the child's initial entry into foster care to meet that definition. Subcommittee recommended reporting with substitute by a vote of 10-0. House Bill 1361 from Delegate Maldonado, as amended by the substitute adopted by the subcommittee, provides that no landlord shall file or maintain an action for unlawful detainer against the tenant unless such landlord has provided the tenant with a proper and effective notice of termination that contains a written statement of charges and payments over the course of the tenancy of the past 12 months, whichever is shorter. Subcommittee recommended reporting with substitute by a vote of 10-0. House Bill 1363 from Delegate Doherty, as amended by the substitute adopted by the subcommittee, provides that in cases of family abuse where the court orders a permanent protective order, the court may require a respondent to pay rent or mortgage on a residence to which the petition was granted possession pursuant to such protective order, and may further require a respondent to maintain suitable alternative housing and utility services to a residence to which a petitioner was granted possession. I didn't like this bill, but I voted for it anyway, as did the rest of us, by a vote of 10-0. House Bill 1382 from Delegate Carnegie provides that for the purposes of domicile requirements for annulment, affirmance, or divorce, any member of the armed forces or civilian employee of the United States military, including a foreign service officer, who at the time of the suit is filed or immediately preceding such suit has returned to the Commonwealth following being stationed in any territory or foreign country, but resided or lived in the Commonwealth for the 6 months prior to that period, shall still be deemed to have domiciled in and have bona fide resident status of the Commonwealth during the 6 months preceding the filing of the suit for an annulment or divorce. So you don't have to come back and stay 6 more months before you can file your suit. House Bill 1406 from Delegate Thornton provides that a court of the Commonwealth with proper jurisdiction may exercise certain powers relating to a foreign decree dissolving a marriage or granting a divorce from the bonds of matrimony if a proceeding is initiated by a non-domiciled party to such divorce, provided that the party domiciled in the Commonwealth is still domiciled in the Commonwealth at the commencement of an action. Subcommittee recommended reporting by 10-0. House Bill 1500 from Delegate Schmidt. I will defer to Delegate Schmidt. He really loves to talk about this bill, Mr. Chair. Yes. I'll go ahead and say it. Keep going. It's fine. This is a bill that has to do with civil actions and provides that in addition to methods for how service of process may be effected on certain corporations, any subpoena issued pursuant to a civil proceeding for electronic records, electronically stored information, or other documents or records that are stored outside of the Commonwealth by a non-party commercial enterprise may be served within or outside of the Commonwealth by hand, certified mail, commercial delivery service, facsimile, or electronic means. Subcommittee recommended reporting 10-0. And then House Bill 1510 from Delegate Lefwich, a recommendation of the Boyd Graves Conference, creates a process by which a person interested in the administration of an estate or the appointment of an administrator in an action brought for personal injury or death by wrongful act against or on behalf of a decedent's estate may appeal an order from a clerk of a circuit court that appoints him an administrator in such matter. The bill is a recommendation, like I said, of the Boyd Graves Conference. Not finally, because there's two more. House Bill 1513, also from Delegate Lefwich, provides that a trustee may reimburse a settlor of a trust from the income or principal of such trust for various forms of tax liability in certain circumstances and in accordance with the Internal Revenue Code, except as the terms of the trust provide otherwise. This is a recommendation of the Virginia Bar Association. House Bill 1516 from Delegate Bloxham allows the appointment of an administrator in any case in which it is represented that a civil action for property damage arising within the Commonwealth is contemplated against or on behalf of the estate or the beneficiaries of the estate of a resident or non-resident of the Commonwealth who has died within or outside the Commonwealth. Under current law, such appointments are limited to civil actions for personal injury and wrongful death. This bill is also a recommendation of the Boyd Graves Conference. Mr. Chair, all those bills were recommended for reporting unanimously, and I so move.
All right, got a motion properly second to report the block that Chair Simon just read of uncontested bills. Do any members wish to pull any bill from the block? All right, seeing no one, I'd ask the clerk to please open the roll. Members, please cast your votes on the block. All members have voted. Our clerk will please close the roll. The block of 13 bills passes by a vote of 22-0. Chair Simon.
All right, Mr. Chair, we have another block of 8 votes on the contested calendar. I'll go ahead and move these substitutes individually. So House Bill 440 has a substitute. I move the subcommittee substitute.
Got a motion properly moved to move the substitute. All in favor say aye.
Aye.
Opposed? All right, substitute's approved. Chair,
All right,
Chair
so this
Simon.
bill, House Bill 440 from Delegate Mehta, as amended by the substitute, adopted by the subcommittee, repeals the suspension of driver's licenses for certain unsatisfied judgments. The bill further eliminates the suspension of a driver's license for unpaid child support if the obligor's individual income for the current year is not greater than 250% of the federal poverty guidelines. The bill has a delayed effective date of January 1st, 2027. The bill was recommended for reporting with substitute and referring to appropriations by a vote of 7-3, and I so move.
Got a motion and properly second to report with substitute and refer to appropriations, House Bill 440. Do any members wish to see recognition on this bill? Seeing none, I'd ask the clerk to please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 440 reports and refers with substitute to appropriations by a vote of 14-7. Chair Simon.
All right, this next House Bill 444 is my bill, and as amended by the substitute adopted by the subcommittee, it creates the Uniform Consumer Debt Default Judgments Act for the award of a default judgment and actions for the collection of certain consumer debts, defined in the bill as an obligation or alleged obligation of an individual to pay money that arises out of a transaction in which the money, property, insurance, or service that is the subject of the transaction is primarily for a personal, family, or household purpose. The bill provides that a default judgment in such actions shall only be entered into if the warrant debt or civil action to recover a consumer debt includes certain statements in the required notice to the consumer as described in the bill. Finally, the bill directs the Office of the Executive Secretary to promulgate a form for the consumer notice provisions created by the bill. The bill has a delayed effective date of July 1st, 2027. And then, I move the substitute. I move the subcommittee substitute.
Got a motion properly seconded to adopt the substitute. All in favor say aye.
Aye.
Opposed? All right, substitute is adopted. Chair.
So the subcommittee recommended reporting with the substitute, which contains the delayed enactment date, and asking you, Mr. Chairman, to please send a letter to the Committee on District Courts and Boyd Graves to ask them to review its provisions before it becomes effective on July 1st, 2027.
Okay.
And I so move.
All right. Got a motion and properly second to report House Bill 444 with substitute. Do any members wish to seek recognition on this bill? All right, seeing none, I'd ask the clerk to please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 444 reports with substitute by a vote of 20-2. Chair Simon.
All right, Mr. Chair, House Bill 901, there's a subcommittee substitute. I move the subcommittee substitute.
Got a motion and properly second to adopt a substitute. All in favor say aye.
Aye.
Opposed? All right, substitute is adopted. Chair
And Mr.
Simon.
Chairman, I understand that there are some additional line amendments that weren't heard in subcommittee that need to be made to the substitute. And I
Ms.
think
Ullman,
council has those line
would
amendments.
you report the line amendment?
Yes, Mr. Chair. So on lines 347 and 410 of the substitute, we're replacing the Virginia Department of Social Services with the local Board of Social Services.
All right, that's the amendment. Can I get a motion to
So
adopt
moved.
the line amendment? All in favor, got a second? All in favor say aye.
Aye.
Opposed? All right, line amendment is adopted and approved. Chair Simon.
So, Mr. Chair, members of the subcommittee, what House Bill 901 now does, as amended by the substitute, is expands the list of persons eligible to file a petition for an emergency substantial risk order. The bill provides various factors that a judge or magistrate shall consider prior to issuing an emergency substantial risk order or a substantial risk order. The bill expands court jurisdiction over substantial risk orders from circuit courts to juvenile and domestic relations district courts and general district courts, and requires petitions against minors to be filed in a juvenile and domestic relations district court. The bill requires a copy of the order to be served on the parent or guardian of the minor at any address where the minor resides, or the Virginia Department, or now the local Department of Social Services, in a case where the minor is the subject of a dependency or court-approved out-of-home placement. The bill also provides the process for which firearms not owned by the subject of a petition are returned to the lawful owner of such firearms. Lastly, the bill provides that any person that makes materially false statements or representations to a court during the petitioning process is guilty of a Class 1 misdemeanor. Subcommittee recommended reporting with substitute, and so I would move with substitute as amended. The recommendation was by a vote of 7-3, and I so move.
Second.
Got a motion, Maldonado seconds, to report with substitute House as amended, House Bill 901. Any members wish to seek recognition on this bill? All right, seeing none, ask clerk to please open the roll. Members, please cast your votes. Ask the clerk to please close the roll. House Bill 901 reports with substitute as amended by a vote of 14-7. Chair Simon.
And so House Bill 1111 has a subcommittee substitute, which I would move.
Got a motion properly second to adopt substitute. All in favor say aye. Aye. Opposed? All right, substitute is adopted. Chair Simon.
House Bill 1111 from Delegate Hernandez is amended by the substitute, increases the cap currently in place for suspension bonds and irrevocable letters of credit for appellants during the pendency of an appeal of a civil action from $25 million to $100 million. The bill also requires beginning April 1st, 2031, and at each 5-year interval ending on April 1st thereafter, this monetary cap to be adjusted to reflect the change in the consumer price index for all urban consumers as published by the Bureau of Labor Statistics of the U.S. Department of Labor. Subcommittee recommended reporting with substitute by a vote of 9-1, and I so move.
And a motion properly second to report House Bill 1111 as substitute. Members have any questions? Want to seek recognition on this bill? All right, seeing none, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 1111 reports with substitute by a vote of 16-5. Chair Simon.
House Bill 1217 from Delegate Oates has to do with livery stable liens, which is not something I ever thought I would need to learn about. And it creates a process by which any person that boards, pastures, or otherwise keeps any horse, cattle, or other animal may impose a possessory lien for the reasonable charges due for such animal's care, feeding, and maintenance, including the number of days for which the lien holder may retain possession of the animal until certain conditions are met, and a procedure for the owner of the animal to dispute such lien. Under current law, the process of imposing a possessory lien for charges due relating to the boarding, pasturing, or keeping of an animal is governed by the same provisions that set out requirements for imposing a lien for the storage of boats, aircraft, and harnesses in a hangar, marina, or tie-down. Subcommittee recommended reporting by a vote of 9-1, and I so move.
Second.
A motion, Maldonado seconds to report House Bill 1217. Any members wish to seek recognition on this bill? All right, clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. House Bill 1217 reports by a vote of 21-1. Chair Simon.
House Bill 1401 from Delegate Franklin clarifies the certificate of taken in eminent domain matter may include a combination of one or more plats, drawings, or plans to provide the description of the property being taken as required by law. The rest of the subcommittee liked that and recommended reporting by a vote of 9-1, and I so move, I guess.
On a motion properly second to report House Bill 1401. Do any members wish to seek recognition on this bill? All right, seeing none, ask the clerk to please open the roll. All members have voted. Clerk will please close the roll. House Bill 1401 reports by a vote of 21-1. Chair Simon.
House Bill 1426 is my bill again, and this bill provides that for judgments entered in the General District Court on or after July 1st, 2026, the docketing of an abstract of such judgment in the Circuit Court shall not affect the 10-year limitation period to enforce such judgment. Under current law, such docketing allows a General District Court judgment to be treated as a judgment entered by the Circuit Court and may be extended in the same manner as a judgment entered by the Circuit Court. So effectively, this says that General District Court judgment is going to be good for 10 years and can't be extended to 20 years the way a Circuit Court judgment could. It just limits it to 10 period. Subcommittee recommended reporting by a vote of 8-2, and I so move.
Second.
On a motion properly second to report House Bill 1426. Delegate Williams, you're recognized.
Yes, Mr. Chair. Question for Delegate Simon.
Delegate Williams.
So can you still take the General District Court abstract of judgment and go to Circuit Court and file it up there to extend it to 20 years?
Mr. Chair, I tell you, Delegate, the answer is no. You can bring it up to the Circuit Court and put the world on notice of it, but it doesn't give it, it still only retains its initial 10-year statute of limitations it would have had as a General District Court judgment. It doesn't give you that right to extend it. We used to have that, and it used to be automatic. Then we said you have to go file for the extension, and now this bill's going a little bit further and saying the statute of limitations for GDC judgments is 10 years, period.
Okay, thank you. Thank you.
All right. Any other members wish to seek recognition? All right, I got a motion and seconded House Bill 1426 to report. Clerk will please open roll. All members have voted. Clerk will please close the roll. House Bill 1426 reports 16-6. Chair Simon.
And finally, Mr. Chairman, House Bill 1479 from Delegate Davis provides that in any action for personal injury or death or property damage arising from conduct that constitutes a felony hit and run, punitive damages may be awarded to the plaintiff. Subcommittee recommended reporting 9-1, and I so move.
Got a motion properly second to report House Bill 1479. Any members wish to seek recognition on this bill? Seeing none, clerk will please open the roll. All members have voted. Clerk will please close the roll. House Bill 1479 reports by a vote of 22-0. Okay, so that completes our docket for today for full committee, but the fun doesn't stop. So we got subcommittee CRIM is civil meeting, Mr. Chair?
We've got one very important bill on the docket.
All right, so civil will meet, CRIM will meet. This will be, these meetings will occur immediately after this committee adjourns, as soon as we can set up, so stay tuned. The committee shall rise.